Welcome, everyone. You are in the Beverly Hills Bar Association Real Property Section program on how will the recently enacted Partition of Real Property Act impact partition practice. I'm Howard Gould, and I am a co-chair of the Beverly Hills Bar Real Estate Law Section. I have been for a number of years now. Very happy to have a really big group attending today's program. I want to let you know what the upcoming programs are going to be. December, we have no program for the public. It's the executive committee will have our holiday dinner, but I want to invite everyone who's a member of the real estate section to come to our executive committee meetings, to join the executive committee and help us plan programs and learn what is new from other XCOM members. And sometimes some of us need help on our matters, and you never know what may come your way if you attend the executive committee meetings. And on January 15th, we have a program by Heather Rosing, a prior president of the California Bar Association. Heather is an expert on legal ethics and will put on a program on risk management for real estate lawyers, and that will qualify for ethics credit. February 19th, we have our annual California Association of Realtor forum update with Jana Gardner visiting us again, which she's done now for a number of years. And if you want to learn about the important changes in the CAR forms from somebody who is intimately familiar with them, that's the program to attend. February 26th, we're going to have a second program in February on real property taxes. Two lawyers from Greenberg Towering, including Chris O'Neill, who has been a frequent speaker for us on California real property taxes. March 19th is our annual review of the prior year's real estate cases with Lawrence Jacobson, former chair of the section and president of the association. And April 16th, another former president of the Beverly Hills Bar, Howard Fisher, is going to do a program on 1031 exchanges. Want to let everybody know that you should, when you have questions, put them in the Q&A. The chat is not being used for that. You can find announcements from the bar in the chat, including a link to the program materials. Finally, the MCLE certificates are sent out by the Beverly Hills Bar very promptly after the programs, so you should look for those in your emails. I am delighted today to introduce our speakers, Curtis Holdsworth, Matthew Taylor, and Judge Elizabeth Feffer, retired. Curtis Holdsworth is of counsel at Bartco Pavia LLP and a member of their litigation practice group. He has represented clients in state and federal courts as first chair trial counsel in matters involving partition claims, unfair business practices, fraud, breach of contract, trade secrets, and other complex business disputes. And he's done this across a variety of industries, including banking, investment, retail, and manufacturing. In addition to his legal practice, Curtis is the founder of Bot Mediation, Inc., an artificial intelligence-based mediation platform that facilitates neutral, data-informed dispute resolution. Curtis attended UCLA, where he obtained his degree in economics, and then the USC Gould School of Law for his law degree. Matthew Taylor, our second panelist, is an attorney and founder of his own law offices, where he focuses on civil litigation and court appointments as a receiver or partition referee. He's a licensed California real estate broker and experienced litigator. He sells 30 to 50 properties annually in court sales, and that includes residential, commercial, industrial, and vacant land. He's admitted to practice before numerous state and federal courts and is also a mediator, judge pro tem, and published appellate attorney with decades of experience in complex disputes. He attended Pomona College and then the UCLA School of Law. Our moderator today, we're very pleased to have the Honorable Elizabeth Feffer, retired. She's been providing mediation, arbitration, and referee services full-time since 2020. She has an impressive track record of successful settlements across a broad spectrum of civil cases. She's also arbitrated numerous cases through hearing and final award. As a judge of the LA Superior Court for 13 years, Judge Feffer served in various roles, including as an unlimited jurisdiction, civil independent calendar court, and civil trial court judge. During that time, Judge Feffer presided over more than 75 civil jury trials, more than 500 civil bench trials, hundreds of evidentiary hearings, and numerous settlement conferences covering a diverse range of complex factual and legal issues. She is also a UCLA grad in communication study in 1990, and in 1993, she received both her law degree from the Gould School of Law at USC and her Master of Arts in Communication Management, also from USC. Thank you all for joining us, and please proceed with our program for today.
Yes, and thank you, Mr. Gould, for the great introductions. So this program kind of came about because I went to college and law school with my esteemed panelist, Curtis. And when I was on the bench in downtown LA, many partition actions. And many, as we'll discuss today, many of them are really, I mean, a judge looks at it almost like a probate dispute that, I mean, obviously it's a civil case, but oftentimes it's, siblings who inherit property from their parents, and one wants to keep it, one wants to sell, and a partition action ensues. And so Curtis had a case in my court that involved multiple properties on a golf course, a lot of really complicated issues. He got through it very well, and I found out later that Matthew was a referee behind the scenes. So there's a lot of great information even before the 2023 Partition of Real Property Act was enacted and kind of added on to the existing partition statutes in California, kind of at the end of it. I think it's CCP section 874.311. Already there were many tactical issues to consider when filing a partition action. And then this new statute, which again, enacted recently, but there really haven't been published cases on it, that kind of changed not just the procedure on how one gets partition in court, but tactical considerations as far as maybe you're the one who wants to file first, or maybe you're the one who shouldn't be filing and you should be responding. So a lot of things to think about, and I'm really thrilled to present this to you. So we're going to go through a number of things, pre-litigation, how they come up, when you might see them, and Curtis will be discussing them, remedies of jury trial, sales and the role of mediation. Curtis will all kind of discussing that. Partition references. This is where Matthew comes in, and I'm on the bench. You don't see all the behind the scenes things that go on with these litigations over the real property, but the partition referee really makes a huge difference and all that. And so Matthew will be talking about that, and then some post-sale and closing thoughts. So with that, Curtis, if you want to pick it up and talk about the statute and the new enactment.
Certainly. I am quickly responding to one of the questions here as fast as I can, so pardon me for the delay. One of the first things you need to figure out as a practitioner is the manner in which the property is held, because it has significant strategic implications for your client in a partition case in a way that's very different than what was the case in my most recent partition action. Specifically, you need to determine whether the property is held as a joint tenancy or as tenants in common, because that is a major fork in the road for you procedurally. And it's something that needs to be determined pre-filing because there could be an irreversible effect or consequence of not determining how property is held before you initiate a partition action. So with that, I'll let Matthew take it and run with it further.
Yes, Matthew.
Well, sure. So the primary issue that we have is that the enactment of the Partition of Real Property Act set a date of January 1st of 2023. And any actions that are filed after that date that involve tenants in common has to go under the rules of the Partition of Real Property Act. If you're filed before that date, or if you're a joint tenant, then you're still under what we're going to call the old rules. And by the old rules, we mean the ones, basically the accumulated rules that have been around since the state of California was founded and amended several times up until the Partition of Real Property Act. But what it means is that for anything filed after January 1st, 2023, you've got two separate pathways and procedural tracks that are existing side by side, and you're going to have to decide with your case which one it goes under and follow the rules for that particular pathway.
Yes, that makes sense, which takes us to the next, and we'll briefly touch on it, and then we'll take down the slide in a moment. So the types of partition in kind, and for instance, raw land, CCP section 872.810, as you can see, by a court-ordered sale, and many of these do resolve, and you don't need to do that, but that is, of course, the option. And then appraisal and buyout, which is the mutual consent, CCP section 873.910. So Curtis, is there kind of a presumption that, you know, that the court would apply, that one is more favorable than the other, or anything you want to kind of touch on the types of partition?
Yes, Judge Feffer. My understanding there is a presumption, but I will qualify that with the new enactment changing that presumption. And so again, I'll let Matthew elaborate on that. But in a conventional, we'll call it partition, when the property is held as a joint tenancy, as opposed to tenants in common. This is articulated here in the waterfall as expressed in the code of priority. So the presumption, if you will, is in kind partition, as opposed to a court ordered sale or by appraisal. In my experience, in kind is quite rare, because most partition matters involve at least a component, if not entirely, dirt or other form of real estate, which is very difficult to be divisible in fairness to the parties involved. So normally you're going to end up in a court sale or a appraisal and buyout scenario as opposed to in kind. I will say this, however, I don't think you should give short shrift to the in-kind presumption. I view that as a rebuttable statutory presumption that still should be affirmatively addressed in the litigation. So my tactic, number one, is I will allege, if I am angling for a court-ordered sale or an appraisal and buyout, that an in-kind partition should not be ordered by the court. And I believe that there's a statutory rubric for that determination to be made by a judicial officer. I think it's articulated in CCP 874.319. There are several factors, in fact, 7, and the statute doesn't indicate one factor being, more weighty than another factor. But you should certainly be aware of what those factors are. And I think as a practitioner, it's prudent to assert, if you do not want an in-kind partition, as to why, explaining why a partition would result in an injustice. And to double down on the allegation, my practice is to propound discovery, so in the form of a request for admission, to pin the other party down to get an admission on their part as to the type of partition that is the most appropriate.
Right, and that makes sense. And one thing, before I go to Matthew, maybe Curtis, you can address it. A complaint for partition under either, I guess, the traditional scheme of joint tenancy versus the new statute on tenancy in common, that complaint does not need to be verified, correct?
That's true. However, it is an area of the law where I expect it would be verified more frequently than other types of litigation. It does give you a bit of a shortcut in certain respects. So I wouldn't be surprised to see a verified pleading, because it's a fairly cut and dried piece of litigation. Not that there aren't intricacies, but it can give you or save you a step or two. But my preference is to file an unverified version and then to seek to pin people down with discovery or by virtue of stipulation.
Correct. And that might be a discussion to have with the client of, even though a verified complaint is not required, perhaps you want a verified complaint, and that of course would prompt a verified answer versus a general denial. So that's kind of one thing to think about. Matthew, before we move on, is anything you wish to talk about with respect to the types of partition and maybe some tactical considerations?
Well, tactical consideration that I have seen, and again, keep in mind, although I'm an attorney, I'm here in my role as a frequent partition referee for the court system. So I'm going to be kind of giving the perspective of the referee. But what I have seen many times is that practitioners representing, especially plaintiffs, want to know how you get as quickly as possible to the next stage of the partition cases. And the next stage of the partition cases where you get to what's called an interlocutory judgment. And that's that's where the court has determined that you're entitled to partition and orders the partition and the method of partition. One way that I have seen people do that is by filing a verified complaint that prompts the other side to file a verified answer. And then based on the verified answer, they'll do a motion for judgment on the pleadings. Because in order to get to the interlocutory judgment stage, especially under the old system, and so the ones dealing more now with the joint tenancy, you really have a very low threshold. You basically have to show that you're an owner and that you haven't waived the right to partition. And if you can show those things, then you've got yourself about 90% of the way towards where you need to get your interlocutory judgment. And that's something I've seen a lot of people do by way of these verified complaints.
Right, certainly. And it's kind of from the judicial perspective, when I was sitting downtown for a number of years in the independent calendar court, there are many, many partition actions filed, and very few would go to trial. And the ones that would go to trial really said this interlocutory judgment stage, those were basically stipulated too, that the trial would basically be for the reimbursements of who paid the property tax, who paid this, who paid that, not really the right to partition or the method of partition. That typically was something that was resolved, although certainly it's not always resolved. The trial was on the other later stage issues. So of course, part of this is what does your client want? And so part of determining who the client is and the stakeholders, Curtis, if you want to talk about the litigation guarantee and how that's so important before you file a partition action.
Sure. I'll just to the point or issue that Matthew raised, I will raise anecdotally. It is uncertain whether a judicial officer would entertain a motion for judgment on the pleadings. I filed a motion to obtain an interlocutory judgment in my favor with, I believe, many of the same admissions in the form of discovery rather than in the form of a verified complaint. And that motion failed in front of Judge Feffer. And she felt firmly that a summary judgment motion is the most appropriate procedural mechanism to award interlocutory judgment. So I would be cautious about attempting to do any other pre-trial motion to obtain an interlocutory judgment other than MSJ. So
right, and it is tricky. Again, this isn't something that is frequently litigated, even though the LA Superior Court has the highest volume of any civil division in the world. This portion of a partition action is not litigated that often. So you may have a judge who's presided over many partition trials, the end of, again, the offsets, this and that. But as far as the interlocutory judgment, the courts just don't see that often. It's not to say it doesn't happen, and I'm sure many viewers who are members of the real estate section and just the bread and butter of your practice is real estate law will have done those trials. But from any one particular judge's standpoint, that doesn't come up that often. So, but certainly kind of the back to the basics, who are the stakeholders and how do you determine? You have to have all the parties before the court. So Curtis or Matthew, if you wish to speak to this issue.
Well,
yeah, sure. Go ahead, Matthew.
Yeah, I was going to say that by statute, one of the most important things you have to do is you have to join in all the people who are potential owners. And so that's really why what you'd probably want to do beforehand is get some sort of a litigation guarantee or a title report or something like that from a title insurance company to identify all the possible owners and lien holders that you'd want to have joined in to the lawsuit.
Yes.
Yeah, this is the one that I am most attention detail oriented towards when I do a partition case. No matter how many times I look at it, no matter how many times I think I figured it out, I assume that I got it wrong, and I double, triple, quadruple check my work. My practice would be to prepare a list or a matrix to identify the property owners, because you can't trust what your clients tell you. Oh yeah, I own it. And you come to find out, well, they're part of an LLC that owns the property, or, oh yeah, I own it. But then, they got a grant deed that they never recorded, so they don't appear on title. There's all kinds of wacky things that can happen. So absolutely, you have to obtain a litigation guarantee, which is essentially a full-blown title report. But you can spare some expense early on. I like to pull what's called a prelim. So if you're close with a real estate attorney or you have one in your side of your firm, if you don't, I would certainly get one involved, get a real estate expert involved to pull a pre-lit or a prelim rather on the property. It'll give you a good snapshot. You can't rely on it completely, but it'll get you started, and it's normally correct. And then you can pull the full title report, a litigation guarantee, to verify everything in terms of who the owners are and getting that right. And I will also say that, as tricky as it is to identify who the owners are, in some instances, it can be very, very murky and tricky to figure out what the property is. And it may not be the case if you're talking about a single APM on like a SFR, like a single family residence. That may be fairly cut and dried. But I'll tell you, if you're talking about raw dirt, if you're talking about some other unimproved property, if you're talking about contiguous parcels, there can be a whole host of pitfalls. So you need to study not just who the owners are, but what is the property, because that needs to be delineated with precision. And I always articulate verbatim the legal description of the subject property, and then attach and incorporate by reference the litigation guarantee to the complaint before it's been filed. It's not a mandate that you have a lit guarantee beforehand, but there's a provision in the code that I'm sure Matthew knows better than I do, whereby the opposing party can demand procurement of a litigation guarantee early on in litigation. So you're gonna need it anyway. The court could order it as well, sua sponte. So you might as well go get it, because eventually somebody's gonna make you do it. Either the opposing counsel or the judge is gonna make you go get that document. And then just anecdotally, Matthew may recall, we had savvy parties in a complex partition case, and everybody thought we knew what the subject property was. But I don't know if you recall, Matthew, there was a crazy little sliver of an APN that wasn't included in the original APNs. And so technically, the interlocutory judgment that we had procured did not cover that sliver. And in our instance, it wasn't an impediment to sell the property or develop it. But it was an interesting wrinkle. And I think even the title report missed it or got it wrong.
Right.
Yeah, I'll usually order a title report fairly early on after I'm appointed, because one of the things that I don't want to do is I don't want to end up on the eve of when we're closing escrow, and that's the first time people realize that there's a discrepancy between the court orders and what the title insurance company thinks the title is, or the legal description for the property is. So that's something that we tend to try to deal with fairly early on.
Right. And we have some just tips on the PowerPoint as well. Again, the lease pendants that will be filed, you have to have the legal description, and certainly the court will want to make sure that all the interested parties are before the court. Again, courts are just the courts have 1,000 to 1,200 cases now throughout LA County in the civil division, and so just time is so limited, and it's double what it was 5-6 years ago. So it's really important that when you go to court, that everything is lined up, and we don't know, and we haven't run it. Might be lien holders and the descriptions. So just it all has to be there. So we put the tips for filing a partition complaint, and this is really important because of the new Partition of Real Property Act and how it applies to properties held, the joint tenancy versus tenancy in common, because there are some unique strategic considerations with respect to filing. So Curtis, if you wanted to pick that up. And then Matthew?
Sure. Sure. And is there a slide before or right after this that is more pertinent to this part of the discussion?
Yes, but this is part of the remedies as well.
I see it.
Part of the remedies is who files first. So right. So the things that really don't affect, or that aren't affected by the change, is filing county. Obviously, you have to file the complaint in the county in which a subject property is located. We've discussed the litigation guarantee. We've discussed the naming of the owners. This is more of, once you get into the remedies, so think very carefully of what remedies you want. And again, maybe your client isn't the one who should file first. So
Yep. Great point. And I'll let Matthew elaborate. But I would be thinking about the remedy that I'm seeking. If, normally the client will have, a pretty clear goal one way or the other. Either they want to be cashed out, and they don't have an attachment to the property, or it's the opposite, and they have an attachment that could be very, very, very strong, to hold on to the property. So you just have to take the pulse of your client to see which side of that fence they want to be on. If it's the latter and they're very, very attached to the property, then you need to tread very lightly in instigating a litigation, because it could boomerang right back at you in terms of the defendant's statutory right to purchase. And I'll let Matthew run with that.
Yes.
Sure. Well, I mean, ultimately there's a range of remedies that you can seek, and this deals with whether or not you're going to be under the Partition of Real Property Act or not. What I think the biggest issue that you have is a strategic consideration on the filing is that if you're under the Partition of Real Property Act, so that means you have tenants in common, you have to go down a route that has a mandatory appraisal and then a mandatory buyout period before you even get to the point about whether you can divide it or sell it. And so that's a procedure that doesn't even exist under the old system. And under the new system, basically what happens is that the inception of the lawsuit, the court is supposed to determine the value of the property, mostly by appointing an appraiser and then conducting a hearing. And then after they have done that, then anybody who is not the person seeking to sell it has the right to buy out the ownership interest of the person who is seeking to have it sold. And they can buy it out at a purchase price that's basically their ownership interest multiplied by the partition or the appraised price of the property. And so there's a whole bunch of statutes dealing with that under the new Partition of Real Property Act. Most of them is going to be around 874, 0.316 and 0.317. I have a lot of criticisms of the way the statute was written, because I think the statute was written in ways that are both sort of ambiguous and unrealistic for the buyout. Main problem with the buyout option is that it doesn't take into account values of the equity in the property versus what the actual value of the property is. So it doesn't deal with how you handle things like mortgages or liens or things like that. It's just silent. And then the other problem that I have is that the mechanism for how you purchase the property is that the person who wants to purchase the property just deposits the money with the clerk of the court, and then eventually later gets a court order confirming their ownership of the property. And I don't know about how people you guys represent, but most of the folks that I see don't just happen to have that money sitting around to do that. To just simply walk down to court and write them a check for $1 million or something like that. Most people purchase property through some sort of a loan or an escrow that, where they're borrowing money, and that's not addressed or potentially allowed under the statute. So there's some real big issues in terms of whether you want to go down that route also.
So Matthew, just to kind of go back on that. So again, the ones that would typically go to trial, and typically siblings. So
Yeah.
it could just be, two siblings. So 50-50 interest, that makes it easy, right? One wants to sell, one doesn't want to sell. Or sometimes I've seen the 3 siblings, right? One wants to sell, one doesn't want to sell, and then they're kind of hashing out their childhood issues, and the one in the middle goes this way or that way, depending on whatever's going on behind the scenes. So kind of, and Curtis, you're free to weigh in on this. So you're the lawyer representing the owner who wants to sell, and now you're the lawyer for the owner who does not want to sell. So, and it's held, under the new statute, the tenancy in common. So what kind of strategic considerations for the one who wants to sell and for the one who doesn't want to sell, as far as filing first and depositing the money, and what kind of any nuances to that we should be made aware of?
Sure. Do you want me to take that one, or do you want to have Curtis handle that one?
You can go first, and then Curtis.
Yeah. I mean, the buyout option is an interesting buyout option because it's a unilateral buyout option. It is the people who don't want to sell have the right to buy out the people who do want to sell. So if you're going to file a lawsuit asking to have the property sold, you don't have a right to buy out your opponent. You don't have a right to buy out the other side, but the other side has a right to buy you out. So if you have a situation where both parties would like to end up with the property and would like to buy out the other one, you may want to pause before you file the lawsuit. You might want to hope the other person goes first, because that gives you a right to buy them out rather than having them buy you out.
I see.
So
Maybe-
that's the primary consideration. There's some other considerations with the Partition of Real Property Act having to do with allocation of costs of sale, depending on whether you've asked to have it partitioned or whether you're opposing it or not. But the primary one with regard to the buyout is basically who goes first and who's asking to have it, asking to have it sold.
Okay, and Curtis, anything you wanted to add? And this also may go into who's entitled to attorney's fees, as far as who files first versus who files second. Anything you want to add?
Sure. There's some, I guess, what I would call an accounting component, and when I say that, in terms of the property being tied up in a partition action, you still have, property taxes due. If it's a commercial property, there could be repair expenses and things of that nature. And in my experience, those things get deprioritized, or there's not a lot of incentive sometimes by one party to be on top of that. And so the other party, to prevent a default or, a punitive late fee, will carry those costs throughout the course of the partition. So it is something that's worth tracking. I mean, that would be something that my client and I would keep track of in terms of the incursion of those costs over time, because that's something that you'd want to be credited for, upon liquidation of the property. And I think a judge, as long as that's well documented, will not necessarily apportion, proceeds 50-50 if one side has incurred, reasonably costs associated with carrying the property. And I think the terminology is something like for the common benefit of the owners of the property, I think would be properly credited in your client's favor if they're solely bearing those costs for the community benefit of the owners collectively of the property.
That makes sense. And then Curtis, before we go on to the next subject, anything you wanted to add with respect to cases that need to be filed under the new rules, the Partition of Real Property Act for properties held in tenancy in common? Again, you're the lawyer for the party who wants to sell, and you're the lawyer for the party who wants to keep it. And again, that might even change during the course of litigation. It's, I want to keep it. Well, okay, well, it's this much, it costs you this much to keep it. Oh, I don't have that, right? So as far as considerations of cases filed under the new statute, anything you want to add?
Sure. I think, given the new statute, you'd want to map out the implications, the ramifications of the buyout option. And you could actually have the manner in which property is held reconfigured by with the help of a real estate lawyer, and have it recorded in advance. So if I did not like the potential implications of a tenant in common scenario, it's possible I would try to broker a deal and have the ownership reconstituted as a joint tenancy. I think beyond that, it's really just a matter of setting expectations with your client. I mean, if my client, wants to liquidate the property, then I'm going to basically tell them it's a matter of time, but there are very few defenses that are going to end up defeating a partition. There are some corner cases where extremely bad behavior on your part, because the court is sitting in equity, I believe, in this type of dispute. So you shouldn't come into court with unclean hands. And if those unclean hands are in conjunction with the property itself or the manner in which it was acquired, then you could be deprived of that remedy. But it has to be fairly egregious behavior to prevent a partition from occurring. And likewise, it has to be fairly egregious behavior for a court to award attorney's fees to one party. It's not a prevailing party standard at all. There's its own provision in the partition statute that refers to attorney's fees, and there certainly is some reported case law about the award of attorney's fees, and Matthew probably knows them, very, very well. But the threshold is quite high. So I would counsel my client, very, very likely that the property will be partitioned, whether you're a plaintiff or a defendant. and B, is also very, very difficult to recover attorney's fees, which is why it is most beneficial to your clients to come to agreement and try to accomplish most things in a partition by virtue of stipulation and order and cooperation rather than full tilt litigation. Because the end result is generally inevitable.
Right. That was always the goal, but again, sometimes you're dealing with the warring siblings, and again, so many, I mean, whenever there was a partition case that looked as if it was headed for trial, I mean, I spent a lot of time with lawyers and chambers. You know what's going to happen, right? And yeah, we do, but the parties just won't stipulate. So we've had a number of questions, and so before we kind of leave this topic, Eric, so again, I mean, this alone can be like a 4-hour presentation on all the nuances of this, because it is substantial. But going back to the kind of the appraisal issue, because I know we very lightly touched on that. So with respect to the new statute, how does that appraisal process work? And what if, you know, your client's on the receiving end of a not so favorable appraisal? How to challenge that? Does this each side just goes to court with their own appraisal, or the referee, or Matthew, if you wanted to weigh in on?
Sure. I mean, if we're dealing with the Partition of Real Property Act, so we're dealing with the new one. And there's actually, this will answer a couple of the questions that are coming up in our question bubble as well. The statute that deals with appraisal is CCP 874.316. And it's got some fairly specific rules. It says basically that if the parties can agree on a method of appraisal or the value, then the court follows that. If the court determines that a full-blown appraisal doesn't make economic sense, then they can determine the value some other way. But if you don't have either one of those two, then the default is that the court orders an appraisal. So the court orders an appraisal to happen. The appraisal then is filed at court. And then you have to give, I believe it's 30 days notice, after which the court has a hearing. And it's presumably someone who's aggrieved by the appraisal could bring in their own evidence that might, and then the judge is supposed to weigh all that evidence and come up with an answer of what is the actual value for the purpose of going forward. And so that's really the first step in the whole process, is this appraisal process.
Now, is the appraisal process under the new Partition of Real Property
It's
Act?
under the new one. It's under the new one, yeah.
Right. Is that before or after the method of partition is?
It's before the method of, if you actually go by the statutory guidelines, my understanding is that is the first thing, literally like first step out of the gates, no matter which way you go, is you get this appraisal. Now, I'm not positive why they have the appraisal for the partition in kind, because it doesn't seem quite as applicable. But you go by that route, and then only if someone's asking for a buyout route, then you go the buyout route.
Okay.
And then if no one has, and if you settled the entire claim with the appraisal and the buyout, well, then the lawsuit's over, because the people who are aggrieved have purchased each other out. And then after that point, then the next step would be for the judge to determine what's the method of partition. If you're still around and people haven't bought each other out, then they go to the next step, which is figuring out what's the method of partition and going from that.
Well, maybe it's because, if this is a state, look, it may not be worth as much as the litigants think it is. And again, are you going to spend, hundreds and hundreds of thousands of dollars litigating something that's worth this much versus this much? And look, that might even go to, the prevailing party attorney's fees of, you litigated this. And again, the court may not think that it was really worth everyone's time to go to trial of, well, I paid the property tax this year, and I paid the gardener, and I did the roof and for this amount of money, and you spent all this. So, that can all be taken into account, just like any attorney's fees analysis. So why don't we talk about just the whole appointing a referee? And again, this is really important, Matthew, about the statutory authority for appointment of a referee.
Sure. I mean, the statutory appointment for referee is that if the court has determined that it's supposed to be a partition, so this is, you've kind of gone through the process of whatever you're going to do preliminarily, determine that it's appropriate for a partition, then the court has the option of appointing a referee for the purpose of carrying out the court's judgment. That would either be doing one of two things: processing the partition in kind, so that would be like a subdivision of the land, or in a case of a partition by sale, the job of the referee is to hire a real estate agent and basically manage the sale. And this is actually really the most important part of the job of the referee is to manage the sale. Now you've got a statute up there that talks about who can and can't be a referee. The general rule, and there's a slightly different statute for referee appointment under the Partition of Real Property Act, but the basic rule is you can't be a referee if you're one of the parties to the action or one of their, or, one of the attorneys or someone like that. But if you're uninterested and impartial, then you can be a referee. There isn't a specific requirement to have a particular license or anything like that. Usually the way that a referee is appointed is that one or the other sides will request from the court that a referee be appointed. The judge will either have someone that they have in mind from past experiences, or the parties will nominate someone and the judge ultimately picks. So the decision on who's going to be the referee is made by the judge.
Correct.
Yep.
And so it seems, I mean, it seems the value is when you have someone who, has to sell, begrudgingly, and it's the party that wanted to keep it, but now it has to sell the property and what won't sign the listing agreement, won't act on an offer, won't sign, right? What kind of difficulties do you deal with, Matthew?
Well, yeah, I mean, look, if you have a standard real estate transaction that doesn't involve the court and doesn't involve court orders, and it's owned by more than one person, you can't even hire a real estate agent if one party isn't going to sign, let alone doing any of the other things, responding to offers, setting a listing price, any of those things. So basically, if you don't have a court order and a referee, then any one of these co-owners has the right to basically veto the sale effectively and stall it out just by doing nothing. And so one of the primary things that the referee has as a power is the authority to sign on behalf of the existing owners. So it's the referee's job to hire the real estate agent, set the prices, respond to offers, sign the contract, sign the escrow documents, all that stuff. And it's done with just the referee's signature. It's not done with the requirement to get the signatures of both owners or multiple owners. Now there's a court confirmation process. So the referee, after he's appointed, can't complete the sale without going back to court, where there's an evidentiary hearing and the judge determines whether or not it's an appropriate sale and things like that. But short of that, it's basically the referee's job to push the sale through, because by the time you get to this point, the judge has already determined there will be a sale and we're gonna put it on the market. And so the referee mechanism is the way that it happens.
Correct. And I can tell you from having these cases where it's the one, again, typically the siblings who inherit the property, it's one does not want to sell. And so, we're going to agree on appraisal. Won't agree. We're going to list it for sale. Oh, no, this co-owner won't sign the listing agreement, and then on and on. Or there's an offer that expires because it's not acted on. So the referee can really short circuit a lot of these issues, and the statutory authority for the referee's powers is on the screen. But Curtis, anything you want to add with respect to using a referee as a litigant and as an attorney?
Yeah, what I would add is that they're just a great quarterback for a host of issues. If it's a fairly cut and dried situation and lots of cooperation, and I would say maybe if you're only dealing with one APN, I pursue a referee if there's any friction at all, especially early on. If I'm in a frictionless plain scenario where the other side is not resisting the partition, litigation process on our end, and or if I'm dealing with a single APN that's straightforward, then I'm comfortable, going A to Z. But if there's any interference or complexities with a multitude of parties or multiple APNs, then you can quickly end up with, a downward spiral without a referee in place. Because a lot of it is just, organization and getting things done just exponentially faster than without a judge. Because it's just like herding cats. Even if everyone is cooperative, if you have 7 or 8 different owners and you've got, a letter of intent to try to, sell a property that has some significant value, you spend weeks tracking people down just to get them to, sign a letter of intent or to enter into a listing agreement to get the property on the market. That's a lot of lost time.
It's always the one property owner who's on a cruise somewhere in the South Pacific and can't be reached at all.
Precisely.
Yeah.
And you can't get any material, decisions made without, 100% cooperation. So when that power is under the roof of a referee. You can really get stuff done quickly. A simple, non-lawyerly way to describe it would be the referee is, got like a power of attorney with respect to whatever needs to be done to effectuate a sale that's reasonable, that a court would do if the court could make that decision, in a day. That's kind of the huge advantage you get. Think of it as like getting like a judge that can act ex parte on what you need when you need it in that amount of time, like 24 hours. You can get basically an adjudication from a referee without waiting 3 or 4 or 5 weeks to get in front of a judge. Every single time you need something done, even getting a stipulation signed, takes time with a judicial officer. So that's the way I think of it. It's like having a sort of a judge in place for all purposes.
Right. And before we move on, and that does make sense. And one thing I wanted to note, and it's on the screen, of the referee or the purchaser or any party may move the court to confirm or set aside the sale. So, my docket in downtown LA in 2018, 2019 was about 500 cases. And now the judge who has my old assignment, old department has, it's 1,000 to 1,200. It's too much. And so again, if you're court, plenty of free time, you could go to court on the motions of the other side won't sign the listing agreement, or the other side won't sign the sign off document, or we can't get it recorded. And again, there would be a shorter time frame. But now the judges are so busy. And look, it's not an emergency that warrants an ex parte application of, we're trying to sell the property and the other side won't sign the listing agreement with the realtor. That's not an emergency. Those aren't exigent circumstances. So you can't come in ex parte. So I think, Curtis, your point, I mean, that is apt, that the referee is kind of the judge sitting on an ex parte basis. The other thing about this point I want to make, again, not speaking for any judges in all circumstances and whatnot, but again, especially when the courts have such a limited amount of time and they are so overworked. If you had to keep coming in of this side won't sign this and this side won't say that, and the referee submits a report to the court, again, if it's a professional referee like Matthew, it's completely arm's length, completely professional, a referee who's known to the court. It's not, the parties, brother-in-laws, best friends, butcher is the referee, right? It's a true arm's length professional referee. The court's going to give a substantial amount of weight to that report. So that's something to think about too.
Yeah, I would add to your point, Judge Feffer, that the referee can really be an advocate for both sides. I mean, they're a neutral extension of power from the judicial officer assigned to the case. And there are a lot of instances where I did not have to be the bad cop. An example would be you get an offer, a proposal from a prospective buyer, and they want to do 4 months of, due diligence on the property. I don't have to be the bad guy. My client doesn't have to be the bad guy. Matthew might step in and say, well, I'm looking at the interlocutory order and it says, if I don't get an offer on this thing within 90 days, it's going to court sale. Or in my opinion, given the market right now on real estate and how uncertain it is, it could be very precarious for this transaction to be delayed by 4 months. I'm not going to sign off on that. I'm going to solicit offers from buyers that will complete due diligence within 60 days. So those are just the types of things the referee
can report. Right. So it's
referee can really
flex, right.
Can really flex, and present it to the court that way, or even before it gets to the court, can push back against, buyers, get more dollars for you, get better terms for you, and you don't really have to be the bad cop. And it's pretty powerful when a referee just says, I don't think the court's going to go for this if I send a report, or I've done this many, many times, and judges almost always reject this sort of exotic provision, or whatever the case may be. It's very authoritative to have it come from a referee.
Right. That makes sense. So I know we have just about 10 minutes left. So Matthew, I have this up. What happens if the sale proceeds and now it's sold? Now, what do you as a referee do?
Sure. Well, by statute, the sale proceeds go to the referee who's supposed to hold them. And then the CCP 873.850 is a really, really important statute that everybody who practices in this area should know about. It answers a couple of the questions, by the way, in our open dialogue or question and answer dialogue from the audience members, and it's basically what happens to the money afterwards. And so what happens is that partition cases have this weird two-phase process. Process one is you get this thing called interlocutory judgment that usually just appoints a referee and says, go forth and sell the property, but it usually doesn't divide up the money, because until you sell the property, you don't know how much you're dividing. And then CCP 873.850 is the statute that gives the court the continuing jurisdiction to divide the money afterwards. And that's really the key to this entire process. If you're selling the property, somebody has to ultimately end up dividing the property. And so that's what ends up happening, is that the referee would either report back to court and say, Judge, I've sold the property. Here's the cost of sale. Here's what I'm holding. Tell me what to do with it. In which case, then the judge takes over again and sets the matter for a trial. Or what I've seen a lot of times is that the statute also allows the court to empower the referee to gather evidence on the subject. And the way that I have seen that enacted most often is that the court will basically tell the referee, go out, set a claims period, gather claims from the parties, come back and make a recommendation how to divide it up. And then at that point, then it would be, I would then file my report at the court, and the judge would decide whether to accept my recommendation or reject it or start all over. But for a lot of the judges, and Judge Feffer can comment on this, sitting down and spending days going through receipts is not really at the top of your wish list.
One day.
Yeah.
You get your day in court.
Yeah. Yeah. And so, basically having someone who's empowered to go off and do that and organize it and then come back and present it all nice and tied up with a little bow on top is something that's very appreciated by many judges.
So Matthew, would you oftentimes put this in your report of you've almost kind of done the accounting of this is what was paid on this date. So there's really no dispute. It's just this party has paid these expenses and this party's paid these expenses.
Yes.
Okay.
Yep. And it would come down to like everybody, this party made these claims. They want to be reimbursed for their, they pay the property insurance, and they say the other guys collected the rent and didn't share it. Right. And then basically, the job of the referee is to gather the claims from the parties, have them submit the evidence, and then assemble that all and make a coherent report to the court about here's how you should divide up the money. Because look, the sale proceeds are a fixed sum. You're not going to get more than that. So the sale proceeds have to be divided somehow. And this is basically a process by which the sale proceeds get divided.
Right. Makes sense. Curtis, anything you want to add with respect to the sale proceeds?
No, the only thing I would add is that there tends to be a waterfall that's fairly straightforward. And normally in a complaint, I try to articulate that waterfall, or it would typically be articulated in the interlocutory judgment. And I think a referee who's assigned to the case, if you fail to articulate the waterfall, would likely redline, or be involved in commenting on proposed interlocutory judgment to help ensure there's no surprises and that expectations across the board are met, rather than people being, confused or surprised, if you will, by how the proceeds are divided at the end. But I will say it's not a lot different than, the sale of a property in accordance with an escrow. There's just a priority of payments that have to be dispersed in order, and the statute is pretty cut and dried on that.
Right.
Well, and I think this is a point at which it's actually really useful to think about, if you're representing parties in action, this is a good point to talk about maybe getting your clients to some sort of a mediation.
Yes.
Because this is the point at which I think that, from what I've seen based on owner psychology, you don't have any holdouts anymore thinking that they're going to stay in the property because the property's already been sold. There's a fixed amount that everybody knows exactly what it is. Right. And everybody that's an attorney or referee or anybody that's billing against the case is billing and taking out of that pile of money before the owners. And so this is the point at which, for the owners, they got really two choices. Choice one is let's figure out how to divide it up. Or choice two is let's keep on fighting about it for a year or 2 years or 3 years through the court system while the money for us gradually is diminished. And, given those two choices, most people I have found, even like hardliners who don't want to be selling their property, will often come around. And it's a great time to get to somebody who's a mediator, who has experience handling these things, who can say, hey, here's what a judge would likely do. So why don't you just save yourself the trouble and agree to it in advance?
Right.
Yeah.
No, certainly. And that's a problem with, I mean, we all love early mediation because you're not spending the money. But again, that's why I kind of mentioned this kind of a probate case that philosophically, if oftentimes there are parties that had some familiar relationship and they, or a family law case, they just kind of need to hash out those issues first. And sometimes if the lawyers agree, you should be settling this. The judge is going to do this. It will be ordered sold. You will be spending all this money. Why not just do this now before you spend the fees? And unfortunately, parties sometimes get caught up in that. But certainly, she said, Matthew, this is an excellent point of, yes, it's going to be sold. We've submitted all the receipts. The referee is writing up the reimbursement, and here's how much money we have from the sale. Do we keep litigating to diminish it? Do the parties want to get some money from the sale, or is it all going to go to the lawyers? And so that's a critical point to discuss. Speaking of money, and I know we just have a few more minutes left, is how does the referee get paid? And again, on the bench, many times it'd say, hey, parties, work this out because it's going to get expensive. It's going to keep being expensive. And there's a certain amount of money that you're going to get from the sale. But again, there's certainly an excellent point of if you have parties who do not want to go forward with the sale and want to obstruct it, that the referee can really smooth the path, especially with the courts being so busy. So Matthew, if you want to speak to this issue.
Yeah, I mean, the question of how a referee is paid, the default rule is that a referee is paid from the sale proceeds that are generated by the sale. So the referee is not like an expert witness who's hired by a one side or the other, or given a retainer by one side or the other, or anything like that. The thing that hires the referee is the order from the court, and the court has the authority to set the fees of the referee. Most commonly, the fees of the referee are an hourly basis. And most commonly what happens is that at the conclusion of the sale, the referee goes back to court and says, Judge, I've done what you asked me to do. Here's my hourly fees, and I'd like to get paid. And then the court has the jurisdiction to approve or disapprove those fees, and has the jurisdiction to allocate among the parties who's going to be responsible for it. Curtis had mentioned several times sort of a waterfall of who gets paid when, and there is by statute, there's a waterfall of who gets paid out of these cases. And the first priority are the costs of sale. So this would be things like escrow costs, stuff like that. Second priority is what are called the costs of partition. That includes the referee fees. It also includes the fees of the attorney's fees and costs for the litigants parties. So those are second priority if the court awards them. And then you get into lien holders, and then you get finally at the end of the waterfall, you get to the actual owners of the property. So
Yes, that's important to know. And
Yep.
Curtis, anything you want to add?
No, I am working on a quick answer to a question here. I think you pretty much nailed that.
Sure. Oh, and then one question to each of you, and maybe each of you would know this, but one of the questions that's come in is, what about liens? That you have a property that's going for sale, and all the liens have been identified. At what point are those kind of satisfied in the waterfall, as you said?
yeah, so by statute, those are actually third in the priority. But as a practical matter, if you're selling the property, they get paid from the sale proceeds, because in order to get title insurance on the sale, the title insurance company will insist that the liens get paid. So basically, if you've got liens, these are things like mortgages on the property, tax liens, child support liens, whatever. Those get paid from the sale proceeds, because you can't close escrow in a regular commercial transaction without handling those things. The title insurance company won't write a title policy unless you do that.
Yeah, and just to follow on to that, is my practice, I think generally, is to include lien holders in
Yes.
the litigation. You might, I call them nominal defendants. It's not a, it's sort of a, a mea culpa, case against them. Often it's a bank, so if it's a partition between a brother and a sister, and the property's encumbered, by Bank of America, deed of trust, then I'm gonna name, B of A, and serve their legal department, or the proper agent for service of process, to make sure that they're in the loop, because I don't want to have any open issues, and I don't like having a disparity between what the title report shows, namely their lien on the one hand, and then them not being a participant in the lawsuit on the other hand, because it could create problems at the end.
Right. Very good. Well, good. Well, that takes us to the end. Again, I know there's a lot, and again, you have the 1 hour format. I think we covered as much. I mean, we could do this for another 3-4 hours to all the nuances, but it's important that lawyers know that there is the new statute, again, relatively new, but you know, all cases filed with the tenancy in common have to be filed under the new statute with the new procedures. And that I think Matthew and Curtis, I mean, as of now, I think there are still no published cases.
I'm not aware of any published case under the new statute, correct?
That's still kind of new. So
It-
it's very important when you're facing a judge that they may not have seen these cases. So it's important to brief these issues and provide the statutory authority. And Chris, anything else you want to say about that? I think you started.
No, super helpful. Even though I'm presenting here, I learn something new every time I get on this a panel discussion like this. So thanks, Judge Feffer and Matthew as well.
Yes.
Well,
Yeah, thank you to both of you. So our contact information is there, and it's been a pleasure spending the lunch with everyone here.
thank you. I enjoyed it very much, and thank you for having. By the way, to the audience members, thank you for the questions. Those are great questions.
Yeah, they're great questions. Sorry we couldn't get to all of them, but we tried to get as many as we could, and they were they're very insightful. So thank you so much.
Thank you, everybody.
Thank you.